monitors, and I've got the camera where some of my notes are, so that I'll be looking at it.
Okay, great.
Good morning, everyone. This is the March 7th docket of the Kansas Court of Appeals. I have been designated as the presiding judge of this panel. My name is Steve Hill. I am proud and very happy to serve with two of my colleagues on the court, and that's Judge Anthony Powell and Judge Amy Klein. This is case number 123366, State of Kansas versus Courtney Douglas Grayson. And before I have you enter your appearances, counsel, I will simply say that we have read your briefs. We have received a research memorandum from our research staff concerning your case. 15 minutes is not very long. And so I suggest that when you begin your argument, you get right to the heart of it as soon as you can. Give us your best shot right up front. Don't delay, because you might run out of time before you get there. If you represent the appellant and wish to reserve some time for rebuttal, please let me know. So with that, let's hear from counsel for your appearances. For the appellant.
May it please the court, Brian Cox of the Kansas Appellate Defender's Office for the appellant.
And do you wish to reserve time for a rebuttal?
Yes, Your Honor. If I could reserve 3 minutes for rebuttal, please.
You've got it. For the state?
May it please the court, the state of Kansas appears by Stephen J. Obermeyer, Assistant Solicitor General.
Very good. All right. Counsel, we're ready for your argument. You may begin.
Thank you, Your Honor. This is a case about a loophole and whether this court can and will close that loophole. Mr. Grayson was not tried within 180 days of his arraignment as required by statute. He was scheduled to be, but his trial was delayed because the government made an unreasonable decision to execute a DNA search warrant in public on the side of the street during a break in the voir dire phase of Mr. Grayson's trial, thereby causing incurable prejudice to the juror pool. Now, had the government's misconduct occurred prior to voir dire and necessitated delaying trial, the result would have been quite clear. The speedy trial statute would have said that that time would need to run against the government. There was still a month left, and the court could also make additional findings to extend that time if its docket was too busy to reschedule the trial, and so that could have happened. Had the government's misconduct occurred after the jury had actually been impaneled after voir dire, then jeopardy would have attached and likely would have prevented retrial of Mr. Grayson. However, because the government's misconduct occurred in the twilight period of voir dire, the district court decided that the government could both eat its cake and have it too.
Counsel,
Your Honor,
use an interesting term there, twilight period. So by that, do you mean that a voir dire proceeding where the panel is being questioned, the trial has not yet started?
Yes, Your Honor, to a certain degree, I would say that that is the argument that I would be making.
Is that what the cases say? Is that what the cases say?
Judge, I recognize that in particular, State v. Bierman is the difficulty here. State v. Bierman.
Explain to me why that doesn't knock you out of the water.
Yes, Your Honor. State v. Bierman addressed an issue that's distinguishable from this case. In Bierman, the voir dire was started prior to the expiration of the speedy trial. There it was 90 days, but prior to the expiration of that period. But in that case, the voir dire panel proceeded to a jury actually being impaneled, and then the trial continuing and commencing. That case did find that that was sufficient to meet the speedy trial, that the speedy trial rights of the defendant were not violated. However, here we don't have that situation. We have a situation instead where a voir dire panel was sworn in for voir dire, but no jury was ever impaneled for that. And so my argument here, Your Honor, is basically to limit Bierman. That yes, Bierman would be correct when you actually get to the evidentiary phase of the trial, but when you never get there, I don't think that anybody's been brought to trial. And I would raise a hypothetical situation that
So now
if
your
somebody were simply,
client asked for the mistrial, correct?
yes, Your Honor, because of the incurable prejudice caused by the conduct of the government.
Well, if it's not a trial, you can't ask for a mistrial.
So there are a couple of things at play here, Your Honor. There is a statute, and I want to make sure that I get out ahead of this. I came to this brief. I did not write the brief, but I am arguing on it. And I do want to note that I think the state is actually correct with regards to the applicability of Mays. In Mays holds that a mistrial can be declared during voir dire. I know that that was not in the appellant's brief, and I wanted to make sure to note that, recognize that, and to the extent that the appellant's brief argues that a mistrial cannot be declared, I think it's necessary that I cede that issue. Recognize that a mistrial can be declared at the voir dire phase.
Thank you for that position, counsel. I appreciate your candor.
However, Your Honor, I do want to make clear that I don't think that that necessarily kills the argument here, because the phrase in the speedy trial statute is brought to trial. I don't think that you've been brought to trial, certainly, and let's remind ourselves that the speedy trial statute is there to implement the guarantees of constitutional speedy trial. If you're simply brought to a proceeding that never results in a guilt or innocence phase, I don't think from a constitutional right standpoint, I don't think that that's going to satisfy the constitutional right to speedy trial. So I think that the phrase brought to trial does not have to have a one-to-one meaning with the whether or not something can be considered a phase of a attempted trial, thus permitting a mistrial to be declared at that point.
Counsel,
So I think that's
practically speaking, don't you have the same harm? I mean, you're still going to have to restart. You've got all your witnesses there. Their subpoenas are out. You've got a jury there. Everybody's ready to go. And now we have to restart that entire process, reschedule witnesses, find more jurors, bring them back in. I mean, that's an extensive process. Why does it make a difference if the jury's been sworn or not sworn when the result is still the same?
Your Honor, it makes a difference because for the defendant, they're still sitting in that time period and they're still awaiting a trial. The other part about it is that once the jury is sworn, as I mentioned, jeopardy would attach, and double jeopardy would prevent retrial, assuming, of course, that the mistrial was caused by the state. In the case that there's a mistrial caused by the defense, I think that that's a very different situation, and then restarting a clock would make sense. However, the mistrial here was not caused by the defense. It was caused by the actions of state actors, of the police, going out and seeking to execute a DNA search warrant someplace that jurors could easily see. During that interaction,
Mr. Cox, I want to ask this question though. It was your client that asked for the mistrial, and his trial counsel refused to allow any examination of the jurors, the prospective jurors. So when you talk about prejudice to your client, do we really know that? We're sort of inferring that there's prejudice, and your client's position was, Judge, we just think this is so bad that we will accept nothing less than a mistrial. So from whatever delay or harm that would have come from a delay, isn't your client asked for that? And isn't that invited error if you're assuming that that was error?
Well, Your Honor, with regard to questioning the jurors, I think that that would almost invariably cause additional prejudice. I don't think there would be any way to get around it. As trial counsel noted in the discussion on that on the day of voir dire, if you ask the jurors about that, did you see anything? Did anything happen? They're going to be thinking something happened. They're going to know that that's abnormal, that it's odd. Personally, I think that a juror would jump to a conclusion that something bad had happened with regard to the defendant. I think that that would be an initial assumption of jurors. And so I think that any questioning, as trial counsel noted, would likely only add to the prejudice. It wasn't curable by questioning them. With regard to invited error, Your Honor, I want to make clear that the state's arguments regarding invited error focused on defense asking for a mistrial, and that being the defense's request. The argument here, and having already ceded that issue of whether a mistrial could be properly declared, I think that invited error becomes, well, invited error is not the case. It was not invited because the defense asked for the mistrial, but they did not ask the district court to make the ruling regarding what happens to the speedy trial clock. After voir dire, the court set it over to a Thursday, a couple days later, that same week, docket. They were still within the original 180-day time period. At that hearing, while we don't have a record of it, because apparently it was unrecorded, we do have from the later pretrial conference, which is volume 6, on page 3, defense counsel, trial counsel quite wisely made a record of the arguments that were presented at that unrecorded hearing. And that's where the defense actually, that's where the appeal actually claims error, which is in the restarting of the 180-day clock. Defense did not invite that error, so invited error would not preclude this argument.
You still have 2 minutes, counsel.
Thank you, Your Honor. Your Honors, as I mentioned, I think that there's an easy way to kind of slice this knot. The issue is with distinguishing from Bierman. In Bierman, as I've noted, the distinction is that they actually did proceed to a trial. The jury was impaneled. By limiting or distinguishing from that holding, noting that this is just not the issue that was addressed in Bierman, this court can find that a defendant is brought to trial when they are actually brought to an evidentiary phase, but that the date of being brought to trial would relate back to the date of impaneling the voir dire. If you don't get to trial, then I don't think that you've been brought to trial properly under constitutional or statutory speedy trial.
Any other questions? All right. Thank you, counsel. All right. Mr. Obermeyer?
Thank you. May it please the court. The state's argument in this case is that this case is about creating a loophole by the court creating common law, interpreting the speedy trial statute in a way that does not, in a way that the legislature did not set out in the statute. The speedy trial statute, I agree, was intended to implement the constitutional right to a speedy trial. And nowhere in the defendant's argument is the argument made that his constitutional right to a speedy trial was violated. That's nowhere in there. This is purely a statutory interpretation, asking this court to disregard State versus Williams and create new law on that point. I found it interesting that my colleague kept using the term mistrial, that the court ordered a mistrial, because it is kind of a term of art, and you can have a mistrial ordered during jury selection, as the case is set out in the state's brief. If a juror blurts out something inappropriate to the entire panel, I find it hard to believe that the trial court cannot declare a mistrial and that you have to proceed with the trial. So State versus Mays controls as conceded by counsel, and Bierman would also control, but Mays came after Bierman, and so I think that applies. And the cases say that once a mistrial is declared, the speedy trial clock is reset. So there's another 180 days. And also, what if this wasn't part of the trial, what if the defendant wasn't present for that? My colleague, Mr. Kittle, always argued cases where the defendant wasn't present for a part of the trial and claimed a violation. Could Mr. Grayson have missed the entire jury selection portion of this? And the state could say, well, that wasn't part of the trial. That he didn't have to be there for that. I don't think defense counsel would argue that because it is part of the trial, and Mays clearly states that. Second point, that this is an issue raised for the first time on appeal as to what a mistrial is, and the court should not consider that. I filed a Rule 609 letter citing State versus Allen that talks about the Court of Appeals should avoid making fact finding in the face of a record that's very sparse concerning what actually happened. State versus Williams says that a mistrial resets the speedy trial clock under subsection F of the speedy trial statute. And the defendant is really seeking a legislative change to the statute that whether or not the defendant created the situation necessitating a mistrial should be added to the language of the statute, and that's plainly not there. There is already a remedy for the state goading the defendant into a mistrial. That would be State versus Witzel, and I think the U.S. Supreme Court Kennedy case. And that argument was not made, and there's not evidence to show the goading of a mistrial. For example, the jury panel consisted of about a dozen jurors who knew law enforcement officers, were related to law enforcement officers, in a case involving obstruction by a police officer and fleeing and eluding, or obstruction of a police officer and fleeing and eluding a police officer. I don't see why the state would want to try and goad the defendant into a mistrial, especially when the state has all of its witnesses there. So there is no Fifth Amendment violation, which would be the remedy if the state did goad the defendant into a mistrial.
Counsel, may I stop you for just a second?
Sure.
I know you're arguing that you don't want us to be fact finders, but there's really no disagreement here. Is there? The voir dire examination had started. They had taken a recess, and what happened with the search warrant happened with the search warrant. And then when the court resumes, defendant moves for a mistrial. That's basically the facts here, correct?
That is the skeleton of what the record is. Yes. I think
a mistrial was asked for and mistrial was granted. And I know it's a term of art, but that's what we have to deal with.
Right. And I don't think every time a mistrial is granted that the speedy trial clock should not be reset.
You're relying on the statute for that, correct?
I'm relying on the statute for that, which says subsection G, if a delay is initially attributed to the defendant but is later charged to the state for any reason, it shall not be considered against the state under subsection B and shall not be used as a ground for dismissing a case or reversing a conviction, which is the situation we have. They're asking this court to apply revisionist history to say that time really should have been the state's time, and there's no showing that the delay resulted in a violation of the constitutional right to speedy trial, not argued by the defendant. nor that there was prosecutorial misconduct related to a delay. And I found it very interesting that defense counsel opposed Judge Osman asking any of the prospective jurors, did anybody go outside during the 15-minute break? Because that would involve going through courthouse security in and out. There were stairs involved because the record shows that Judge Osman's courtroom was not on the first level. The state talked to Officer Herb, who said there was nobody in the vicinity. When the state asked, let's talk, I think the question can be wordsmithed to ask, did anybody go outside during the break? That this mistrial was basically, if this were a basketball game, a flop. That the defendant had an opportunity to get out of, to call a foul on the state, that this happened. And by the way, why didn't the officers execute it out in the back of the courtroom or outside the courtroom if they, were trying to goad the defendant into having a new trial? And defense counsel initially said this happened on the steps of the courthouse, and then backtracked and said, well, it was at 7th and Quincy. So we're a distance away from the Shawnee County Courthouse where it happened. So there's a lot of facts here that this court would have to find as to whether or not there's a prosecutorial misconduct, I guess, if that's the argument made. We have no jurors, no prospective jurors that were out there and saw any of that. One of the state's witnesses was in plain clothes, at least, and it could have looked like a conference talking to a group of people talking to the defendant. It takes about 2 minutes to execute a search warrant involving a swab, and the record is unclear as to what sort of confrontation there was, if anything. So I think there's a lot of findings that this court would have to make that are really not in the record, especially when you had Officer Herb, who was there available to testify. And it would seem very unusual that you have a witness, police officer witness, who's also supposed to execute a search warrant on the same day, and let's multitask while you're out there and collect the DNA swab and just put it in your pocket for the rest of the jury trial. That makes no sense. And again, the state argued that this was premature, the motion, and that we should ask the jury, and if anybody went outside, if there's any smokers, any walkers. A conscientious jury would want to be back in 15 minutes as Judge Osman ordered, and may not want to risk having to go through courthouse security or anything like that. So the mistrial, it was granted, but if the judge had denied it, I think the state could have defended the denial of that mistrial very easily in this situation. But as it turned out, Grayson avoided all the prospective jurors who knew or were related to law enforcement, were prior jurors or prior jurors in criminal cases, got rid of all that by getting the mistrial that he requested. And he used the term mistrial. He didn't say, some remedy where the proceedings are continued, but this isn't really a mistrial. And the other part of the speedy trial statute is under subsection G. If a defendant or attorney requests a delay and such a delay is granted, it shall be charged to the defendant. If it's not a mistrial, this is a delay charged to the defendant, and the speedy trial statute should not be used as a weapon to have the case dismissed, as it happened in the Queen case cited in the appellant's brief. That's just not the case. I think that's about everything I wanted to say, unless the court had any questions. But I think that the court should not create a common law exception to the plain language of subsection F. The court should not find facts based on this undeveloped record as to whether Reeder and Herb were executing a search warrant, because that's how the brief of appellant read. but there are not facts in there that show this situation. And I think for all the reasons that the defendant got the mistrial that he requested, avoided the jury panel that he may not have wanted to see, and got a new trial. I do want to mention State versus Allen again, that was in the 609 letter, talking about preservation complications from a limited record or a problem, and that the appellate courts should not be finding facts that aren't in the record. And the court said the speedy trial statute does not create a fundamental right, as the panel held, because the speedy trial statute simply fixes procedural guardrails to protect the constitutional right to a speedy trial, which was not violated in this situation. And even if the court did address the issue under subsection G, it would not change the result, because the time cannot be changed. The time cannot now be assessed to the state later, as the defendant is attempting to do. So for those reasons, the state would ask this court to affirm the defendant's convictions.
Thank you, counsel. Any other questions from the panel?
No.
All right, very good. Let's see, 3 minutes, counsel. Is that what you wanted for rebuttal?
Yes, Your Honor. Thank you. The first thing I want to note is just that the quotation that we heard from 223402, the speedy trial statute, I think the state omitted some crucial language in there. There's, at the end of that, in addition to the unless not considering such delay would result in a violation of constitutional right to a speedy trial, there's a bit more after that. It's or there is prosecutorial misconduct related to such delay. So I think that that's the situation here, where this time can be counted against the state. The second thing I want to address is whether the appellant is asking for a common law exception here. I want to make clear that that's not the. If the court wanted to do that, I would not object. But I think that the framing of our argument, is that it's a matter of interpreting the meaning of the phrase "brought to trial" in the speedy trial statute, and whether that was met. The language of 3402F, which is the part that talks about the time limitations in the case of a mistrial, grant of a motion for a new trial, or remand from the Court of Appeals. That language says that the time limitations shall commence. It assumes that the original time limitations have already been met. And so I would say that the court could hold that there can be multiple limitations periods, certainly, but that first one is not explicitly nullified by the language of subsection F of 223402. And lastly, Your Honors, just one more note that I think the state kind of got at here, and I just want to make sure to note. There was discussion in the briefs about whether this was a hostile encounter. I want to remind everybody, make sure that we're seeing this in context, that there were other individuals that were coming and asking to stick something in Mr. Grayson's mouth. Whether that was authorized by a search warrant, and it appears to have been certainly legal if it had been authorized by a search warrant, that's still a hostile act, even if it is a legal act. And so I think there was an inherent hostility in what was going on at that corner. The suggestions in the briefs that must have been hostility on Mr. Grayson's part, I think, are just that, speculation.
Thank you, counsel. Anything further? Wow.
There
Very
you
good. Thank you so much, both of you. Counsel will take this matter under advisement and issue an opinion as soon as we can. Very interesting case. We thank you for your good argument.